Now tell us about that ruling. First of all, it was 6-2. What does that tell you?
Well, it tells us that support for preferences seems to be waning. All five of the judges who most people thought, well, they're not much in favor of these kinds of preferences, said, yes, Michigan can say no if they want to. Joining them was Justice Stephen Breyer, usually on the liberal wing of the court, but Breyer is pretty strongly committed to democracy, and he said, well, if the people of the state don't think that preferences are a good idea, who are we to say they can't do this? So there are 6 votes in favor of allowing states to say no more preferences. Now, this ruling, by the way, doesn't say that states have to have preferences or never can have preferences. What they're saying is that it's all right if the people of the state want to pass a law saying no preferences. The 2 dissenting justices, Ginsburg and Justice Sotomayor, who wrote a very long, very edgy, angry-toned, and not very legal opinion. It was mostly about policy, why she thought they were getting the policy wrong, even though this was not a policy matter, it's a constitutional matter. Her dissent accused the majority of turning the clock back and avoiding the importance of race, which led to some very interesting back and forth between the members of the court. Chief Justice Roberts said, well, we're not turning the clock back and we're not abandoning race. We're simply saying if the people of Michigan aren't persuaded that having preferences is a good thing in discussing and redressing race, there's nothing we should do to prevent them from having that in their Constitution.